Hello. How we doing, Pasadena? End of the day. How we feeling? 3XP. Give yourselves a round of applause for staying focused when it's almost 5 p.m. We appreciate it. So for the end of the day, we want to do something invigorating, exciting, sexy. We're talking law. We're talking regulation. We're talking gaming. We're talking Web3. But in all seriousness, this is very important stuff, so you should pay attention. My name's Lutz. I'm a reporter with Decrypt. And alongside here, we have three lovely, very sharp lawyers with a lot of expertise in regulation who are going to walk us through some timely topics today. So I think we should just go down and introduce ourselves. But Ira had the lovely idea, as opposed to just saying, who we are and what we do. We'll ask, what are your origin stories, and how is it that you ended up on this stage here today?
Thank you so much, Sander. And we should also say our favorite animal or something, because we're the only thing standing between you guys and happy hour. So hi, I'm Ira. I started in gaming. I'm going to date myself. I helped with the development and the launch of the PS4, and then from console gaming, I ended up moving to mobile and web gaming at Kabam. And then my founders and I were thinking about sort of the next step and what is the next thing. And I think that's really why I'm here. What is the next thing in gaming? I think is always interesting, because gaming is the one industry that always leans in on the best and the hottest and the most groundbreaking technology. So then we were thinking, let's start working in blockchain and Web3. So now at Superlayer, we're a venture studio, and we focus on getting Web2 ideas into tokenized consumer products. And we really do believe that the next wave of ownership, of democratization of the economy, is absolutely going to be through Web3, and gaming is the best place to be.
Excellent, thank you. Kristina, why are you here? How are you here?
Great question. Hi, everybody. I'm Kristina. I am an attorney. I work at a company called SoRare. We make digital sports trading cards for the modern age. So kind of like the paper basketball cards and baseball cards that you all grew up with, we've digitized them, backed them with NFTs, and made them available on our platform. You can also play them in a free-to-play game. So I started my career as a tech kind of generalist, working in startups, actually in the Paris startup ecosystem, it's a great ecosystem. There's a lot of incubators and a lot of things happening over there. And then about last year, I moved over into the Web3 space, just in time to join SoRare as we were finalizing our agreements and partnerships with the MLB and the NBA. So a really exciting time, really cool company to work for. So yeah, nice to meet you.
And Tyler, how about you?
Yeah, hi everyone. My name is Tyler Harttraft. I'm a partner at Bull Blockchain Law. We're a boutique law firm that's based in Philadelphia that works exclusively with blockchain and cryptocurrency clients. We do corporate work, securities, compliance, and regulatory advising. I found Bitcoin in law school, fell down the rabbit hole way back when. Started mining cryptocurrency, had a lot of fun with that, started serving as an advisor to founders who were developing companies using blockchain technology. And the DAO report came out in 2017, and we launched the firm shortly thereafter.
Beautiful. So to get into it, of course, regulation and legal issues with Web3 gaming have something to do with regulation surrounding crypto. And never a dull moment in crypto. This has been a very fun week for crypto regulation. There were SEC actions this week against Coinbase and Binance, which were two of the last who hadn't yet encountered that in a major way. But Ira, first question for you. As opposed to looking about, there's a lot of uncertainty right now. It'd be easy to spend this entire time saying, well, what do we not know and what might happen? But you're all lawyers, right? You work with this stuff every day. There's also a fair amount of certainty to be had. So especially with everything that you help your clients and companies build with relation to tokenized gaming ecosystems, can you speak a little about what we do know, what certainty game companies or builders can have right now so that people aren't just sitting on their hands? Because there are people making stuff right now, and how is that possible in this climate?
It's a great question. And actually, coming back to you with what's uncertain and going to what's certain, I'll start by saying before gaming, I was actually a securities lawyer. So before Howey test became something kind of like cool and cutting edge, I was working with the Howey test based on securities. And as some of you probably do, actually raise your hands if you've ever heard of the Howey test. I'm just curious. Oh, okay, so pretty educated crew when it comes to regulation. Yeah. So you guys know that is basically the test that one is supposed to impose on anything to determine whether or not it's an investment contract. And for a bunch of reasons, the 1933 and 1934 regulations were passed in order to oversee any sale of a security, because they want to protect consumers from losing all their money by buying snake oil. And then in 1946, there was a case about orange orchards, and that's the Howey test, basically determining whether or not people entered an investment contract in order to buy a share in the orange juice that might come out of this orchard. And so now here we are in 2023. We're dealing with some frameworks that may have updated slightly, but are still not actually designed in any way to address new technology. So I think all of us absolutely agree that none of us should be operating without guardrails. And there are rails that exist in crypto. I think the general feeling is that implementing these incredibly antiquated rules on a new technology don't work. And just one point, which is Coinbase, if you guys are following what they're saying in response to these allegations against them in this lawsuit, they're basically saying there is no path to registration with the Securities Exchange Commission, that they've done everything they can do to follow the law. They've done everything they can do to try to register under antiquated frameworks, but the SEC is not accepting it. And so here you get the situation with an actor that has 50 money transmission licenses state by state. They've done all the financial rules and all the regulations. They followed them to the T. They've gone to talk to the Securities Exchange Commission multiple times because the SEC claims to have jurisdiction over them. And yet they can't get clarity, and instead they get a lawsuit. So having followed this very closely and being someone who practiced securities law for quite a while myself, I find it very challenging to have these unknown areas where it might be a security. There's literally no way every crypto token could possibly be a security. It just doesn't work with how they're used. So what do we know? We know that gaming, actually there's a potential in gaming to use Web3 for the reasons that I believe it has the power to do. Let us not forget Vitalik Buterin, founder of Ethereum, the godfather of all that we know in modern blockchain and Web3 and crypto. One of the reasons why he started this because he's a big World of Warcraft guy. And then Blizzard just basically changed something without any ability for him to do anything about it. Basically kind of rug pulled him on something that he cared a lot about. And he was like, centralized power sucks. Let's get a situation where I get real ownership over the stuff that I've been working on in my gaming. And I think that message resonates to a lot of gamers and a lot of developers. There's an opportunity here. So what we do know is that gaming can be that tool where the token isn't just to try to speculate. You buy it, you hodl it, you hope it goes up in value. Gaming is where we can build true utility into each token. Basically using it as a currency within an application, using it as an ownership token to make sure that everyone knows who you are, using it for identity. A lot of people have been talking about this throughout the various panels during the day. There's a lot of use cases for tokens that are real and true, and we in the game industry can build it. So I think what we do know is that there are rules that we have to follow. The money transmission, make sure that the payment rails and how you do all these things, keep transparent, keep clear. But then I think there's so many areas where there is gray area. We'll work through it together, but we builders got to keep on building because I do believe that gaming was where it began, and gaming is where the future lies for Web3.
Kristina, related to this, there is some stuff that we don't know. Like Ira was saying, there's gray areas, but there's also not just individual, small or even moderate-sized Web3 companies building in this space. There's also huge legacy organizations, such as you were speaking with, we work with, the NFL, the NBA, who wouldn't want to get involved in something if it was going to blow up in their face, who are getting involved in NFTs, in tokenization. And can you speak a little bit to your perspective with that? working with, I don't know if you call them Web 2 or Web 1 or pre-web organizations, but who are engaging in the space and continue to, what does that show you about how durable or forward-thinking or how long-lasting this space is going to be as it continues to grow?
Yeah, that's a great question. So I think a lot of our sports leagues, both here and abroad, we started out as a football company, so we have, or soccer, whatever you want to call it, but we have a lot of football, thank you, with the accent. Yeah, so we have a lot of partners with really valuable IP, enduring IP that have been around for a long time that, you know, have very well-known brands and want to protect that. So I think as a Web3 like gaming company, you want to emphasize to them that, you know, you don't operate totally in the Wild West. Yes, there are great areas, but, you know, we still have IP lawyers. We're still going to make sure that the contracts make sense. We're still going to make sure that, you know, their copyright is protected, that nobody's counterfeiting their brand and that kind of thing. So I think really like emphasizing to them, you know, that we're doing our due diligence, that we are still following the law, and then where we do have gray areas, like we're being thoughtful about it, we're doing our due diligence. We're not just kind of taking something and running with it, but we're being really careful about their brands and that we really value the partnerships and are doing what we should do from a legal perspective, I think really helps to encourage those companies who are already interested in innovation, right? It's kind of just a matter of convincing them that we are going to partner with them in innovation in the right way. So we definitely put a lot of emphasis on that, like as we're developing the partnerships. Even like being really careful about explaining, you know, how an NFT works, how ownership works, how we're licensing their IP to our users, and like what's owned and what's not. So yeah, it's definitely like an education standpoint, and then also just like kind of like back to basics law. Like what law applies here? What should we do as a product?
And Tyler, drawing off your experience working in this field with securities and regulations and gaming, and you know your familiarity with crypto as well, what would you say when clients come to you, you hear are some of the biggest misconceptions about how this stuff actually works in a legal sense? And does that mean that things are a little more complicated than people think, or they're actually simpler and not as scary as people might worry? Or what is it that you encounter most frequently on these subjects?
Yeah, I think one of the biggest misconceptions is around the securities issues as they relate to the tokens, and it's you know, it's because we have such a lack of clarity around this issue because of the SEC's refusal to engage in rulemaking, refusal to provide guidance that's helpful. And it's unfortunate because someone asked me this question today, you know, what's the most frustrating part about your practice? And I said it's the fact that we spend so much time with our clients on hypothesizing about what the SEC may or may not like about this statement, or you know, this social media, this tweet, or this Medium post, and things like that. When you're trying to launch a token-based incentive system, it gets really ethereal, and trying to forecast that is really difficult without that clarity. And so, you know, when the regulatory body is out there saying that there's plenty of clarity and just taking regulation by enforcement, I don't think that like the real world practical situations that these clients are in are being acknowledged, and it really is hampering innovation. And I know that's a big talking point and like buzz phrase, but it really is a problem. And so I think the biggest misconception is around, you know, what is the security, what is the investment contract, as Ira was referring to, and what's been carved out as the legal point to defend, and it's been echoed by Coinbase in their responses on social media and on in their postings, is really that the tokens are not the investment contract. The investment contract is the agreement with the initial purchaser and the business, the issuer. What happened, you know, whether that token is given as part of that contract as compensation doesn't turn the token into a security. You know, the fact that I contract with someone to maintain an orange grove and I receive oranges does not turn the oranges into a security. And so that distinction has been drawn, and it's a great distinction, and you know, the legal community has done a great job fleshing that out and starting to defend that point. whereas the SEC would really just like to conflate the token and the investment contract completely because it fits their legal theory, and without that, they really can't make their case. And so that's really, I think, the biggest misconception out there from a legal standpoint, and it has a broad impact on how these companies can operate.
So I guess now maybe let's try to turn this a little like practical, because everything you all said is extremely enlightening and helpful, but it's like, let's say, for example, I'm in the audience right now. Let's say I'm that gentleman in the toga-esque t-shirt over there, and I am a Web3 builder. I am wanting to bring a game to market. Let's maybe go down, and this kind of gets on the misconception thing. What is just like if there's one essential takeaway about, at this moment in time, bringing a tokenized gaming ecosystem into reality, and let's say in America, for example, because that's where we are, what's just like one good practice to keep in mind, besides hiring a good lawyer who can handle everything for you? And maybe let's start with Ira and go down.
Well, I'm going to drop a bit of a bomb. I'm going to say, if you want to have a tokenized economy that you as a project are going to sell or in any way distribute to the regular public in the United States, don't do it. Unfortunately, right now, the one thing that is clear is that there is a very likely possibility that the way the US is going currently is that every token issuer who sells to the general public in the United States could be deemed an unregistered security offering. Like, it's really hard, and I say this with a grain of salt, because the SEC is busy going after Binance and Coinbase. Are they going to have time to look after every project that exists? No, definitely not. So you could take that risk and just go ahead and issue this token. But the other thing that I will say as a pragmatic way to handle it is that the United States, unfortunately, thinks itself to be the primary audience and the main adopter. But the fact of the matter is, you guys saw what happened to Axie Infinity. You guys saw how entire populations actually were able to make money and survive through the pandemic because of the power of Web3 gaming. And Axie Infinity's model wasn't perfect, as we've now learned. It shouldn't be play to earn, it's play and earn. That's what we should all aspire to. Have the earning be an element of the game, but have the gameplay, as always, be fundamental. Game's got to be fun. Game's got to have people there because they want to play it, and the earning part can be a part of it. But I just want to flag that if you were to have a game launch in the United States and just gate away the US when it comes to the token issuance and sale and any distribution from the platform, and then just open up that world outside of the US, it's something to think about. Obviously, that's easier to say than to implement, but part of what I want to say is just the fundamental rule is that if I have someone coming to me and saying, we want to launch a token and get rich quick, I'd say, not really a good time for that. But if people want to say, I want to build an incredibly fun game and have elements there that will enable gamers to own, to earn, to be a part of the ecosystem in more of a way than just tapping into platform and then everything's subject to license. It's not really owned, it's not really yours. If you want to tap into that potential, you can do it. But I would just say that you need to be very careful when it comes to an issuance and a sale of a token to the general public within the US. But you geo-block it and then you're good.
Kristina, I know that you deal with not quite tokenized ecosystems, but you deal with NFTs, right? So is that a little less of a nerve-wracking sector, or is there still caution? Or I guess for people in the audience, again, who are considering getting involved with the types of products that you advise on, what would be that key piece of advice?
Yeah, the risk profile is different, right? I think right now, as a country, from a regulatory perspective, we're really talking about crypto when we talk about digital assets. NFTs haven't really entered into that space yet. There has been a lot of activity actually on the state level, but not so much on the federal level. So one thing we maintain as people who use NFT-backed products is that NFTs are already regulated. And that's what I would really emphasize to anybody who is looking to build a project that included NFTs, It's that there are already consumer protections that apply to these. So think about your end user. Think about who is going to buy your NFT-backed collectible or your collectible digital asset. Like, how can you be fair to them, and what do they want? I think like that's kind of the basis of our consumer protection laws, is just fairness. Are you disclosing the things that they would want to know if they got into a bind? Are they clear about what they can and can't do with the item that they're buying? Are they clear that they're buying an item and what they're getting? So I think like starting from that premise of like, okay, who's this person who's buying my token or my NFT, and what do they need to know, I think is like the best place to start in terms of NFT projects. Like just remembering, there's already consumer protection regulations that apply, and you need to follow those, I think is super important.
And I actually love what you're saying, Kristina, because while we're talking about all these like incredible ideas of technology going off into the space that we don't even know, it comes down to terms of service. Like what you're saying, as a lawyer, like all projects still need to have the terms of service. They need to have contracts. They need to have those legal trappings that have already been developed. So absolutely, it's not the Great Wild West. Projects still need to have some counsel of some sort, or use the terms of service that actually are transparent. And the more transparent, the less angry users, the less problems you'll have with the law.
So Tyler, do you agree with your co-panelists and what they've said thus far? Like NFTs, if you're cautious and thorough, okay. Tokenizing an ecosystem, maybe hold a beat, a slight danger zone at the moment. Are you on the same page, or would you push back on either of those? And then also, what would be that key piece of advice you would give a builder right now?
No, I agree, and I think both points were highlighted well because, to be corny and borrow some gaming terms, there's two entries to your castle that you want to defend, and regulatory is one, and that gets the most attention, sometimes too much so that it's to the detriment of worrying about, consumer protection and your terms of disclosure that Kristina was just highlighting, and that's definitely a big concern. So you want to be worried about any civil suits for misrepresentation or consumer-based suits for anything that you're maybe stating in your terms of service or in publishing on your Medium or on your website. And so it's really important to have a policy about how you're communicating about these rewards or any tokens that you're issuing, your game systems and how they can be earned and things like that. And so because it is such a confusing space for the consumer as far as terminology, we're all still coming to an agreement about terms and definitions, and we're not fully there yet. I mean, even the term NFT gets so twisted and turned and applied in many different situations to we all need to understand what an NFT is. Is it the unique alphanumerical code, or is it the expression that we're talking about, the expression of a card? And I think that's really important to distinguish, especially if you're talking about situations where there's ownership involved and the purchaser expects to own that NFT or be able to license it, sub-license it, things like that. So I think it's really important to flesh out that side of your compliance consistently.
And just talking about this, and Ira, I think you mentioned something to this extent, like, is this just a weird position to be in as a lawyer? Like, if you think of all whoever you went to law school with and what they're doing now, or people you've worked with earlier in your careers, like most lawyers, like, okay, it's a murder, I know how to deal with that, or it's a merger and acquisition, I know how to deal with that, or it's a tort, or whatever it is, versus being, at the crest of the wave of something that, to some extent, is entirely unknown, and you all in your careers are, to some extent, acting as advocates for this industry just as much as builders and entrepreneurs are. If you could just speak a little bit to even what that's like as a career choice, or contrasting with other types of law, because law is usually very black and white, and this is like, I would assume, an astounding amount of gray, as you've all alluded to.
It's so much fun. I love my job. I actually don't know that many lawyers that can honestly say deep in their hearts that they love what they do. I freaking love what I do. And I mean, it's not without a little bit of gray hair, certainly, but there's no reason to lose sleep, because this is fun. We're building the next wave. Web3 is literally a new dimension. And I think that being at the cutting edge of it and actually helping to guide it is necessary. And this is what I tell, I talk sometimes to law students and lecture in law schools, and people are asking kind of like, oh, it sounds really scary. Like, don't be dissuaded by the hype. obviously the front page headlines tend to like to talk about crypto as a place for, all of the crimes to happen. And I mean, honestly, a suitcase full of dollar bills is still a better way to commit a crime than something that's always immutable on a blockchain. I like to tell them that what people seem to forget when they look at the headlines on criminals and fraud, crimes and fraud, it's always been crimes and fraud. Like if you cheat, if you lie on your terms of service, it's a crime. Like you can't do that. It has nothing to do with crypto. What I like to tell them is that what to think about in Web3 is it's a technology. It's beyond just what one would generally think. And it's a technology that's not owned by a single centralized party, be that a big tech platform or a sovereign government. And just kind of heads up, newsflash, why is everyone so scared of this? Is because it disrupts the incumbents, the banks, the financial institutions, the government dollars and yen and whatever it might be. It is disruptive, and there's a fear that it could replace it or threaten it. And so it's a fun place to be in the law. Because, not for the faint of heart, but all of us have had practice areas that have handled more traditional areas of law, and we can take that and implement it and help guide. And I think what the industry needs more than ever is people who are the game developers that know what they're doing. They've been around the block. The lawyers that actually practice securities law and understand what they're talking about. The people that really do get it, and they come up and they say, not a flash in the pan technology, we explain why this is here to stay and why it's, in our case, why it's legal or why it can be regulatory compliant. There's a huge education that we're just, scratching the surface. We haven't even started. But I think we're in the forefront of getting to define that world, and that's why it's really exciting. So if any of you guys out there are lawyers, join us, because it's a really fun place to build the next generation of technology.
And Kristina and Tyler, if either of you have thoughts on this, I don't know how close you are with lawyers who work in other fields, or if you still keep in touch with them, but is what you do, you feel different than that? Or even on a strategic level, do you have to go about thinking about how you do your work a bit differently than if stuff was, black and white and was fixed?
Yeah, it is definitely different. Like Ira was saying, it's very exciting. I think it's just like a totally different field. Like if I was doing estates and trusts or something, I think that, that field of law is very well established. Like we're still drawing from English common law, how we go about, administering somebody's will. The cool thing I think about Web3 and Web3 gaming and being a lawyer in this space is that it's a really creative way to practice the law. If you were to launch a cloud service today, like you could look at Google's terms of service, you could look at Microsoft, you would have like no shortage of examples of what to put in your terms of service and how to explain the concepts. Like it's been like lawyered to the ends of the earth, right? Last year when we were updating our terms of service, we were kind of looking to see other examples, what other projects we're doing, and nobody really had them. Like every once in a while you would have like the errant, like, hey, don't steal anything on somebody's like GitHub repo, but it wasn't enough, from a lawyer's point of view. So I think, for us it was really cool. We kind of had to start from scratch and be like, okay, what do a Web3 games terms of service need? Like what do we need to explain to consumers? So it was almost like a very interesting like creative writing exercise combined with law. And I think that it's just a really creative way to practice the law that you just don't get in, other fields, corporate, anything like that. Like you kind of have to start from scratch, go back to your like kind of basic premises, and then build out from there for this new technology.
That just made me think of a question, and maybe Tyler, you can answer this. But also, if you wanted to have anything that you were going to say on that subject too, go ahead. But like if I run a company right now or a gaming company, and I'm looking for a Web3 lawyer who can make good decisions for me, because it could involve my company getting shut down or sued, by the government or something. It's a new emerging field, and I don't mean for you to speak ill of anyone in this. It's like, are there how should someone go about finding a Web3 lawyer in this field, because it's not quite as established in others? And are there things to look for and things to avoid? I don't know if that's something true or not. And then also whatever you were going to say about
Yeah, I think it's tough for the lawyers and it's also tough for the clients because it marries various disciplines, right? So I might be advising a project and we're getting into the meat of things and we're talking about IP issues, we're talking about securities issues, we're talking about commodities issues, we're talking about tax issues, we're talking about, all of these, and those are all separate departments in law firms, in the big law firms, right? And so it can be challenging, and I think especially for the client because you don't necessarily understand where your legal weaknesses or strengths lie until you start having those conversations with lawyers and having those consultations. But once you get a sense of what the issues you should be focused on are, then you can get a better sense of the type of lawyer that you need to hire. Like, are you looking for a lawyer that's kind of more like an outside counsel that almost functions like an in-house counsel that can handle a variety of issues? Do you need someone really, really specialized that knows, every SEC case since how he started? And so it can be a little bit difficult to go about that as a client, for sure. Advice on that as far as how to go about doing that, I think you just have to have a lot of conversations, unfortunately, and find someone that works well with you, because there's also not only different expertise, but there's different approaches to handling things. We get clients who come to us and tell us, I was told I couldn't do any of this, and I basically can't do anything. And some lawyers are much more conservative, and we try to take a really practical approach. So, we're going to give the answer candidly, but we're also going to provide the practical effect of things. Like Ira mentioned earlier, is the SEC going to be able to focus on, an early stage project that's just thinking about launching a token now? Or do we think, maybe, that type of project is not going to be front facing for a couple years, and hopefully by then the legislation that's on the books now is law, and we have a path forward. And so there's definitely a practical element to this type of advising and kind of considering the space and everything that's happening at every moment in time, which is, the landscape is constantly shifting.
So we have a few minutes left, and maybe it'd be a good idea to open up to audience questions. If any of you have questions, no worries if not. But if you do, you can raise your hand and I'll run down and give you a mic if you'd want to ask any of our fine panelists about any of these subjects. Going once, going twice. In which case, oh, there we go. Okay. Oh, okay. Thank you.
Yeah, free billable hours, you guys. You have 3 lawyers here.
This is free consultation. Very valuable. Could be up to $90, $100 if they get a good minute or two of your time. More than that? Oh, this could be worth tens of thousands of dollars. So I get in there. You have a question?
If a Web3 gaming company is trying to launch their project in multiple markets around the globe, what advice would you have to a company to make sure they're regulatory compliant or can deal with the issues that may come up, since different countries have different laws?
That's an excellent question. I'm glad you asked it, because actually that's a really relevant one. The fact that you even thought of it means that you're heading down the right direction. I would say it really depends, and this sucks. I know people hate it when lawyers say it depends, but it kind of does depend. So sort of the first questions to ask are you launching and issuing a native token? Are you selling it to the general public? Or is it an NFT? Is it something that's mostly in-game with some link to mainnet? A lot of that matters, because if, for example, your platform takes money and distributes something back out, then there's money transmission and financial laws pretty much in every jurisdiction. It's the securities law issue that I think is troublesome in the United States right now, because if the US takes a position that every cryptocurrency, Ethereum, maybe, who knows, maybe Bitcoin's the only one that's not. If that's a position the US takes, then there's always just this sort of veil of risk on every tokenized project. That's the part where I think it's helpful to be outside of the United States when it comes to the token. But I'd say the easiest way, honestly, is to start looking around. Like, before you hire a lawyer in every jurisdiction, which gets incredibly complicated, you could actually do, and this is where, unfortunately, lawyers start to get unemployed. You could do a lot of good Google research and just find out, like, India. What's the current status? South Korea. South Korea is actually great for gaming companies generally because they have a lot more flexibility. Hong Kong's coming up as one of those great jurisdictions. You think about all the countries in the world, and actually there aren't that many that you'd really want to focus on that market and focus on those users. So maybe start with that as well. What kind of game do you have? What markets are you looking for? What audience are you hoping for? So there's a lot of research you can do on your own before you get down to like forming a company and figuring out the money transmission laws in that company. But I will say again, like from my perspective, financial compliance is absolutely necessary because that can be criminal in many countries. It's a securities law question on just like blanket throwing every token into the same bucket. That I think is where the United States needs to catch up with other countries.
Thank you. That's such a great panel, guys.
Thank you.
My question is about companies going offshore and then still offering token sales. And I have heard some rumors on Twitter that people basically, these companies go offshore, they set up somewhere else, and then they're still able to offer token sales, and that buyers, apparently there's no way to like verify that the buyers do not live in the US. And so some of these buyers are just basically pretending that they don't live in the US and they're still able to buy these tokens. I don't know if any of you have heard about this phenomenon. I mean, crypto Twitter, I guess. But if people are doing this, like, who could be liable? Is there a way to verify that someone lives in the US or not for token sale purposes? Is the game developer liable if people lie about their residence country? Do we need to like do heavy KYC to protect ourselves as game developers? And can companies or users get away with this kind of stuff as like a loophole in the crypto space right now?
Happy to take that. Yeah, so there is a rule, it's called Regulation S, that basically says that if the transaction is happening outside of the US with non-US persons, and the parties are truly outside of the US, and it's not touching the United States, then it's not, that sale is not going to be something that the SEC is going to look to regulate. Of course, there's issues with flow back to the United States, so the SEC does want to make sure that the persons who purchase that, who are non-U.S. persons, are not just turning around and selling it to U.S. persons. And so you need to be careful with that if you are an issuer, to make sure that the flow back isn't happening within the appropriate time frames. And it's a strict liability issue. So you could be making a good faith effort, and a violation under that statute is a violation, unfortunately. The good faith effort to do KYC and geofence usually pays dividends as far as enforcement is concerned, but it doesn't mean you didn't violate the statute. And so what companies can do is they can do their best as far as KYCing, using a technology software provider to do the due diligence and collect the information, and that's typically what happens. And so your question about your second part of the questions, I think it was layered in there. Right, yeah, and I think one of the tricky things is it's a misconception, right? So if you're based in the US and you form a company offshore, and you're the beneficial owner of that as a US person, well, that offshore company is, for securities law purposes, a US person. And a lot of people can get tripped up on that because they think, oh, I have an offshore corporation, I'm avoiding the US laws, they can't get to me. Well, the statute is written such that it contemplates that situation. And so for the purposes of the securities laws, that entity is looked at as a US issuer.
One last question from the gentleman in the toga shirt.
Thank you. I actually have a follow-up question sort of based off of that one. Should we ever expect any legal action against VPNs? Are they covered? Are they safe legally, or could they ever start getting dinged?
Sorry, I missed that first part.
Oh, should we ever expect any legal action against VPNs?
VPNs. What we use to
like
watch.
VPN, so you say that you're in Switzerland when actually you're here. An action against a VPN. Oh, that's an interesting one. I mean, they would say that it's just a technology tool. So the radar detectors, you know, if you detect the cops' radar, like, are those illegal? Like,
wasn't there an act recently that was passed to make or not passed, proposed to make VPNs illegal, right? I don't know that it got any traction, but it was a huge issue that arose recently. I don't know what the follow-through was.
And if the question is, will it pass? I'm like, will anything pass these days with the gridlock in Washington? I don't know.
Right.
Yeah, and I think at the end of the day, they're going to try to like bring enforcement actions against the wrongdoers, right? Like, I think a lot of the times regulators and enforcement agencies take a more or less tech-neutral approach. So the VPN is not necessarily the problem, it's what you're doing with the VPN, right? Are you kind of doing something illegal or something that they would frown upon? In that case, like what they would probably do, and I can't like predict the future, but I think they would take action against the wrongdoers and not necessarily like the technology. Like the getaway car is not the problem. The problem is that you like robbed a bank and now you're like fleeing the scene of the crime kind of thing.
And not to have the last word on the panel that I'm moderating, but it's interesting, just what this made me think of is like, you know, it's not just crypto where these big questions are like different laws in different countries with the internet. Like, I don't know if, Tyler, this is why this is in the news, but you know, Montana just banned TikTok. And like, the US, as far as I'm aware, for the first time is dealing with these things where like, state by state, there are different websites or different, you know, programs that you can access here or not there, even though you could drive across the border in a second. This seems like a messy topic, and crypto and Web3 are going to be a part of it, but it seems in the next few years it's not going to be driven just by this sector, so there's probably a lot to develop there. And on that note, I think we are out of time, but if we could please give a big round of applause to our lovely panelists. Thank you guys so much for staying with us at the end of the afternoon. May there be a happy hour in your near future, and thanks so much for coming.